Okay, I guess I'm going to get started. I don't know if you guys can all hear me okay, or if maybe I should get the other mic, or if this, can you all hear me? All right. So anyway, my name is Alan Gura. I'm Vice President for Litigation at the Institute for Free Speech. We like to sue school boards, among other people who violate your First Amendment rights. So just by a show of hands, I know some of you are going to raise your hands. How many of you here feel that you may not be entirely free to speak your mind at your local school board? Okay, that's too bad. How many of you have had your microphone cut or otherwise been intimidated from speaking? That's pretty bad. Well, we're here to do something about it, and what I'd like to do in the next hour is discuss with you what makes for a good First Amendment lawsuit. What's the kind of thing we're looking for when we go after a school board for violating your rights? And we actually had a little bit of news today, this week, in the school board front, and I wanted to go over some of it with you to start. And I'm going to play only a short introductory 4-minute video, so you sort of set the stage of what we're dealing with and what happened this week. So this is from the Pennsbury School District in Bucks County, Pennsylvania, outside of Philadelphia. And I don't know how many of you have seen this video before. Maybe some of you have or not. Some of you have seen it. Maybe. Oh, wow. Okay, well, feast your eyes on this then. This is from what happened early in 2021.
Board members misrepresented facts around equities in schools, presented unindexed statistics that have no reflection on Pennsbury.
You know what, I'm going to stop you there. We're not going to tolerate misrepresentation of facts around equity. So that's irrelevant, and you can stop.
In your opinion?
No, you can stop, Mr. Daly. You're done.
You sure you want to do that, Mr.
Yes,
Ramirez?
I do.
All right, we'll see you in court, sir. Just a reminder, you didn't need an equity.
I said you're done.
You didn't need an equity.
I said you're done. Mr. Daly, sit down.
At the last meeting, the equity and critical race theory audit was reviewed, and the crux of that was that there were different...
I apologize. It's not what it's called. That is not...
That's how I'm addressing it, and
that's not what it's called.
That's what I'm calling it.
I understand, but
Then
that's not what it's
your
called.
comments are irrelevant then if you're not going to call it by the right term.
This
is the equity policy.
Look, some people call
It's
it...
the equity policy.
All right. I'm telling you what I think it is, but if you'd like, I'll use your term, although I disagree with it. Fair enough?
Equity policy. Go ahead.
The curriculum that's being used here in Pennsbury, diversity, inclusivity, and equity, and it's known by other phrases nationwide, often cherry picks facts to create what I feel is a predetermined narrative, which again stigmatizes certain groups of people. And yet there are many facts that are not included in the curriculum, which I think just aren't included because they don't fit the official narrative. For example, first-generation Nigerian immigrants excel to the top of the academic socioeconomic ladder of success. Or
All right. We're just, you're getting into irrelevant things. We're just going to stop you there. You're done.
What made you the king
You're
of the
done.
sport?
You're done. You're done. We're not going to take it, that is irrelevant.
That's important because it breaks
You're done, Mr.
No, I'm not
Yes,
done.
you are, Mr.
No, I'm
Marshall. You're
not
done. You are done.
I will sue you as well.
You're done.
No, I'm not.
You're done.
What? Based on what?
Board Policy 903. You are
What
now
is it?
being disruptive and disorderly. You're done.
You're the one
You're
who
done.
said- You know what?
You're finished.
You can count on being sued. I'm gonna sue you.
Robert Abrams.
Robert Abrams, Lower Mayfield Township. I want to thank Mr. Daly. While we were sitting here, he got me some numbers. Apparently, what was sent out by the district, 65%, considering for the diversity program, 65% are extremely happy now, 27% were neutral, 8% were unhappy. So we're going to build a multi-million-dollar program for the 8% that are unhappy. I'll bring the 8% in here Let them meet with all.
All right, you're done. You're done. We're not going through this again, Mr. Abrams. That is not what the equity program is about, and we're not going to sit here and listen to you. You're done. You're done. You're done.
Honestly, after what you did to the last two, I think you are.
You're done. You've already violated the board policy. According to the policy, your public comment has been terminated.
All right, so here's how this ended. Oops. No, it's okay. I don't need the. I'm done with the screen. You guys can turn the screen off. So, I'm done. I'm done with that. But so I'm happy to tell you that last night the Pennsbury School Board had another meeting, and they approved the settlement in the lawsuit, which paid each of 4 plaintiffs nominal damages for violating the First Amendment rights, $17.91, and attorney fees of $300,000. So, and the nice thing about the attorney fees, it doesn't all go into my pocket personally. It goes back to the Institute for Free Speech and also to our local counsel on the ground, Michael Gottlieb in Philadelphia. But the payment, of course, as you might imagine, comes from an insurance company. And when insurance companies write checks like that, they tend to have conversations with their other insureds about what their school board policies and procedures ought to be. So we can bring lawsuits that have the systemic effect, and it's quite nice. This is not the only settlement we've achieved this year. We've also sued successfully the Francis Howell School District outside of St. Louis. They didn't fight us as long or as hard. The attorney fee settlement there was in the neighborhood of $70,000. Similar behavior from them, and I'll get to that later. And also I can say that IFS is proud to represent the Moms for Liberty chapter in Brevard County, Florida, where I'm sorry to say we've not yet had much success. The judge is not entirely friendly to our lawsuit, to say the least, and has ruled against us a number of times, but the case is on appeal, and it's going to head to the appellate court maybe several times, and it's far from over. When you litigate, what matters is not the first decision, it's the last decision. And what we know about strategic litigation, whenever you sue for a violation of constitutional rights, everyone knows that no matter what happens in the district court and the trial court, someone who's unhappy is probably going to appeal it, and that's where it'll be settled. In Pennsbury's case, they wisely chose not to appeal in November when the judge enjoined their speech policy. We later had some additional festivities in the lawsuit. I can tell you that Pennsbury's policy has been remarkably improved. It's consistent now with the First Amendment. And by the way, the board solicitors there that you saw running that meeting have been terminated themselves from the school district. So they gave some bad advice. It wasn't, but in any event, next week we do expect to file an additional lawsuit that I can't talk about. I wish we would have been able to do it this week so I could have told you about it. But we have others on the drawing board. So what do? Our mission at IFS is to protect political speech, your right to participate in the democratic process. We don't take positions on the issues that you want to talk about. So we're not going to litigate for the proposition that mask mandates are bad or anything against trans ideology. I definitely have my own views on those. As you can imagine, they're very consistent with yours. But our mission is to protect your right to speak, not the truth or falsity of the things that you're speaking about. And we have plenty of work to do in the nation's school boards. Now, litigation does not solve all problems. There are sometimes cases where a lawsuit is not going to help you for various reasons, and I'm going to discuss some of those. And also, not every lawsuit is necessarily First Amendment lawsuits. There's been a lot of discussion about parental rights bills. Sometimes there are other constitutional provisions at play. Many parents have had success using the Freedom of Information Act, the right to know process in their various states to get information. And there are other legal things that you can do, but I'm here to talk to you about what we can do with your right to speak and your right to petition, your right to assemble, so you can make democratic change and express yourselves. What does this look like? What does the landscape look like legally? Because you should understand a little bit about how the Supreme Court views the First Amendment in something like a school board situation. Whenever somebody claims that they have a right to speak in public, the Supreme Court says that the kind of right you have, the extent to which your right is protected, depends on the type of forum in which you are speaking. Now, at one end of the spectrum, you have what the Supreme Court calls a traditional public forum. The streets and the parks are the perfect example of that. You can say whatever you want to say out in the park or in the street. The only regulations the government can impose on you in those areas are as to time, place, and manner, and the government can definitely regulate those areas, but it has the burden of showing that, that those regulations are appropriate. And we can all imagine what those might be. If you're in the park, the government can say at a certain hour the park may be closed. They can tell you, well, if you want to speak on the sidewalk, don't obstruct traffic. Stand over here, not over there. And of course, they can do things about the manner of speech, for example, noise regulation, things like that. School boards are not parks or sidewalks. They're what the Supreme Court calls a limited public forum. And a limited public forum is a place where you wouldn't otherwise have the right to speak, except the government created that space for you. And that's what happens at school board meetings when they designate a time for public comment. And so you do have First Amendment rights there, but they're a little bit different than what you have out in the street. The first rule is that the forum is organized for a particular purpose, right? School boards they exist for you guys to talk about the schools. And the school boards are allowed to restrict the content of your speech in a school board meeting to make sure that it relates to the purposes of the forum. So if you're going to talk at the public meeting, they can say it needs to be on topic. You can't talk about, UFOs or the Kardashians or whatever. It's got to be about a school. And they can also limit you to agenda items. And that sometimes is unfortunate. We have some school districts, many school districts, where there's a public period, speaking period for agenda items, and then later on they're for anything school-related. They can do that. Some schools contact me and they say, look, we have a problem. It's agenda item only, but they never put our issues on the agenda. And the answer to that is, I'm very sorry, you need to elect a different school board, somebody who will be there who's going to put that on the agenda. The other thing is, to be consistent with the purpose of the school board, of the forum, the school board can have additional rules. So, for example, they can limit your time to speak. Time limits are not going to be unconstitutional. Why? Because there's only so many hours in the day and only so many hours for a school board meeting, and the meeting can't last forever, so they can ration the amount of time that people have to speak. Sometimes people don't like 3 minutes. They want 5 minutes, 10 minutes, 20 minutes. There's nothing we can do about that. They can also limit who can speak because, after all, it's to run the schools in a particular community. So they can limit a speech to people who are residents, taxpayers, people who have some actual stake in the governance of the school system. I personally love Matt Walsh. I don't know if you guys remember when he decided he wanted to go speak in Loudoun County, Virginia, not far from where I live, and they said, no, you have to be a resident here. And they can do that. Unfortunately, they didn't get to hear from Matt Walsh. But those rules are appropriate. What can they not do to you? Well, the big rule is they have to be viewpoint neutral. Once a topic is on the agenda, once it's allowed under the rules, any viewpoint is fair game. If DEI is on the agenda, you can say whatever you want about it. And you can use whatever words you want to use. And those are the basic rules. They can restrict what you talk about, but not your views. They can regulate speech to make sure it's consistent with the purpose of the school board. But again, they have to be viewpoint neutral. Now, unfortunately, school boards, as you all know, do a terrible job of teaching civics. And you don't have to like or even know anything about the Constitution to be a school board member. So we see all kinds of violations going around the country, some of which may be a little creative, but which can generate potential lawsuits. And here are some potential lawsuits that we see. The first thing is sometimes the policy will just declare that there are categories of speech that you can't have. We see school boards that try to ban abusive speech, dog whistles, microaggressions, speech that's offensive, inappropriate, intolerant, antagonistic, uncivil, whatever. These kinds of categories are not viewpoint neutral. The Supreme Court has made very clear that giving offense is a viewpoint, okay? And you are allowed to offend government officials in our country. The school cannot decide which ideas are offensive and which ideas are inoffensive. The whole purpose of the First Amendment is to protect offensive speech. If the speech is perfectly fine and nobody's bothered by it, it's never going to get censored. So your right is, if anything else, the right to offend someone who would otherwise shut you up, but for the fact that you're protected by the Constitution. So whenever we see these categories of speech pop up, those are good lawsuits. Another problem with some of these categories is they're also vague. There's a very basic element of constitutional law is that part of having due process means you need to know what the law requires and expects of you. If a person of average intelligence can't figure out what's allowed and what's prohibited, the law is unconstitutionally vague and it's going to be struck down. What is inappropriate speech? I don't know. These things are kind of hard to tell. Another thing that's a feature of some of our litigation, and it's going to be a feature of additional litigation, is that some schools are uncomfortable with so-called, I'd say, sexy speech. We see this with the books that you all want to read back to the school board, and suddenly they're scandalized by this. Look, for better or worse, hardcore pornography is constitutionally protected. So now that doesn't mean you can take your clothes off at a board meeting and engage in various acts. That may not be appropriate to the purposes of the forum, so they can enforce decorum. I know some people are disappointed. But can you read things? Yes, you can read things, and there is a doctrine in our law about obscenity speech that has like no redeeming social value, and it's exclusively aimed at the prurient interest. I got to tell you, obscenity prosecutions in this country are very rare. I'm not sure there's even been one in many years. So obscenity is more like a colloquial term. It's something that we might say, well, that's obscene, but what is legally obscene as far as the Supreme Court's concerned? Almost nothing. For sure, reading aloud from a book is never going to be obscene. And it does not really matter whether or not children might be tuning into the school board meetings. We all know that our kids love to watch school board meetings. That does not matter. There is some old law from the 70s about, they're the 7 dirty words you can't say on the air, because back then they thought that, during certain hours of the day, there's no way to protect children from the radio. My kids don't even know what a radio is. Like, Dad uses funny words, stereo. Why is that? Okay. But no, you can read from the book. If they don't want you to read from school library books, maybe they should not put those books in the library. But in any event, you're allowed to use those words, and that causes us to want to litigate when we see stuff like that. Another restriction that we've seen, and this is what happened in St. Louis, in the St. Louis area, in Francis Howell, there was a strange board rule, which I guess makes sense if you think about it in the abstract. They said, well, you can't have any advertising in the school. We want to have a commercial-free school, and we don't allow political campaigning. When you come before the school board, you should be not giving a stump speech. You should be talking about the governance of the schools. But the way they used it was very interesting. There were parents there who did not like the school board. They formed a PAC, a political action committee called Francis Howell Families, and the Francis Howell Families had a website. And on their website, they had all kinds of information about CRT and masks and all those usual issues that the school board doesn't want you reading about. And when the parents would come before the school board, they could say almost anything they wanted, but if they uttered the words Francis Howell Families or gave the website address, the school board said, you're advertising your website or your political campaigning, and so they cut the microphone. So we sued, and we said, no, you're not advertising a website by mentioning it. And by the way, you can mention any other website at the school board meeting. So you could mention like cdc.gov, you could mention the teachers union website, and these, there are many websites discussed at the school boards, but this one bad website, you couldn't talk about it. That got struck down, and it ended up in a $70,000 attorney fee settlement. Another strange practice we see a lot of, many school districts have a rule that prohibits speech which is personally directed. And they want you to talk to the chair. It's a formality that you're addressing the chair. And, that may be a close call, and maybe, that wouldn't be the worst thing in the world necessarily. I think you should be able to address anybody who's there on the dais, but it's interpreted very differently. A personally directed rule is often turned into what I call the Voldemort rule. Those of you who are Harry Potter fans know you're not supposed to set it. I'm sorry. He who shall not be named, that's right. So you cannot mention the name of a school board member or the name of the superintendent or the name of a teacher. If you mention them by name, you'll be cut off. And we've seen people have to use all kinds of pronouns and euphemisms. That is not allowed. There have been lawsuits on that. That's actually another aspect of the Brevard case that we're fighting, and it's an aspect of the law in other places. It's one of the things that got struck down also in the Pennsbury case. The other issue that we've seen is when the school board controls access preferentially to the hearing room. Okay, this is a Brevard issue where you show up to the school board meeting, and guess what? The room's already full of people with the rainbow flag or whatnot, where for whatever reason the school board has decided to give preferential access to the room to people with one political persuasion, crowding out the people who may feel differently, and that of course affects oftentimes who gets to speak and who gets to be visible and who gets to be part of the mix. We think that's not appropriate, and that's something that we're fighting. Another issue that we've seen, and this was an issue also in Pennsbury, is when they censor the recordings. And this is, a lot of times they'll record the school board meetings, they'll put them on the website so you can go watch the meeting some other time if you can't watch it live. And funny things will happen. A speaker that they don't like will be deleted or will have their language cut out. Now, the schools are not required to broadcast or post on the internet their meetings. It's unfortunate that sometimes we've seen schools say, well, no more streaming of this, just as a way to, control people seeing what they're doing. The First Amendment does not require them to broadcast it, but once they're making a recording available, if they're editing that recording based upon the viewpoint of the speaker, and then we're only going to show some viewpoints and not others, and they're making that political judgment, that's going to be a problem. They're going to have to explain that to a judge if they get sued, and the explanations are probably not going to be sufficient. Another issue, and this is also something we took care of in Pennsbury, is remember I told you that they can make sure that only school residents, district residents, and taxpayers can talk? So what if they say, yeah, you can come speak, but you need to start by announcing your home address. And we know what that's about, because they don't want, they want, Antifa taking notes in the corner, and then there are problems. So no, there's nothing wrong with the school verifying your address to speak so they know that you are properly in the school district and should have time to speak. But there's no reason why they should be able to require you to announce that to the world, and who knows what else. That is clearly meant to intimidate, that kind of doxing. The judge in Pennsbury didn't like that either. Other things that we've seen sometimes, there are all kinds of gimmicks they can come up with. We had one school that I've been looking at where they barred people from bringing demonstrative exhibits. So like you couldn't come in with a poster board or wave a book at them. I could see where there might be a limit on the size or the material. If say, well, that's a fire hazard if you bring in it's 30 by 20 foot thing and it's blocking the path. But you should be able to express yourself, I think, with basic demonstratives, and of course, sketchy books are the one that people think of. And this is all just at the school board hearing. There are other First Amendment problems that, of course, happen in schools. Any kind of compelled speech is something that we look for. So if there's some kind of a loyalty oath, you must write a diversity statement to work here or to get tenure or promotion. That's something that we're interested in doing. Generally, the government cannot require you to express or adhere to a certain ideology as a condition of public employment. And also compelled speech is an issue with respect to some of these walkouts that are becoming popular, where the school sponsors or promotes a walkout, and then a child who may not agree necessarily with the message might feel compelled by the environment to join in. You don't want to be the one kid who, no, I don't believe in this issue, teacher, where the child knows that the teacher is very much involved and gung-ho about some position. The child can reasonably fear being bullied, perhaps being graded down. So those are also issues that we would like to address, and I'm sure that there may be many others that the evildoers can imagine and create for us to address. So the question then, all these things are happening, who can sue, okay? Who would make a good plaintiff? Well, it seems kind of a silly thing to say, but I'll say it anyway. People who want to sue, you have to want to do it. We get a lot of calls and inquiries from people, and they say, gosh, this is happening in my school or my city or whatever. Do you want to sue? No. Well, I can't do anything with that. So, but if you've been injured, meaning you are the one who has been censored, then you have a good claim. You also have a First Amendment claim if your speech has been chilled, if you are not doing something because you don't want to get arrested, fined, thrown out. You don't want to bear the consequence of what happens to people who cross the school board. If you are refraining from speaking because of the consequences that you reasonably fear would befall you for that speech, then you have a sufficient injury that the federal courts will recognize, and you can go ahead and go to court. Sometimes you have less standing if you're saying, well, I'm going to do it anyway. Well, then the court's not going to recognize that you have the injury of being chilled, although it may still be the injury of you're being censored. I know sometimes people don't want to necessarily put their name out there in a federal lawsuit. There are times where you can sue anonymously or pseudonymously, basically use your initials or something, John Doe lawsuit. Those are tough. The First Amendment favors public knowledge about things, and that includes knowledge of what's going on in the court system. So sometimes judges are very reluctant to allow people to proceed anonymously, but there are situations where that's allowed if you can show that there's a credible, real-life threat of retaliation. If you're going to be hurt by having your name attached to something, you may be allowed to keep it quiet. It's something to explore if there's a good story about it. Also, if you are going to be revealing personal facts about yourself, things relating to sex, then yes, sometimes courts will let you proceed anonymously. But for the most part, you are going to have to put your name on it, and you're going to have to be out there. You shouldn't fear that because that's what it takes. You can't be a joyful warrior if you're not going to be a warrior. But I want to stress the joyful part, and this is so important. One of the reasons why we love the Moms for Liberty is because you take this joyful warrior stuff seriously. It is much easier to represent people who are pleasant, decent, people who would appear sympathetic to the wider community. You don't have to be a nice person to have First Amendment rights. We can represent Nazis, if we wanted to, but it's a lot harder, okay? And especially remember, you are not litigating in this perfect vacuum where it's just you and the judge who happens to be a robot. The judge is a person. The judge's clerks are people. They go out there. They watch the news. They see what's going on in the community. And if you're the kind of person who's a jerk, if they're good, they'll still enforce your rights. But you never know how that impacts a decision maker. And also, you are in the court of public opinion always when it comes to constitutional litigation. Your message is not just to get directed at the court. You also want to leverage that lawsuit into positive attention for your cause in the media and in the wider audience. So please be joyful. Please continue to be good people. I have seen a lot of lawsuits that come to us that we can't take because it was great until the speaker started fighting with the cop, and don't do that. If your rights are being violated and they're cutting you off, okay, it's on video. We'll deal with it. But if it comes to the point where we have to take a recess because you're being pepper sprayed and tased and taken out, that's harder to litigate because then they also have an interesting claim for resisting arrest or whatnot. Don't do that. But you don't. I don't have to tell you this, but some people need to hear it. So what can we get in court? I touched on this a little bit earlier. Declaratory relief, a declaration from the judge that this is unconstitutional. That's important because we can set precedent with that. We like getting injunctive relief. That is an order from the court commanding the school board to knock it off. Do this, don't do that. That's always something that is in play when the policy is ongoing. We always ask for nominal damages if something has already happened to you. What's a nominal award? $1, something small. Usually we ask for $17.91. Year that the First Amendment and the rest of the Bill of Rights was ratified. Why do we ask for this? No one gets rich off the $17, okay? It's not about the money. It's because sometimes you have a situation where you sue a person, you sue a government, and they read the lawsuit and they say, okay, we'll never do that again. Here, we're getting rid of the policy. We promise, we won't ever do it. And if the judge believes that, then there's not a claim potentially for injunctive relief, and the lawsuit might be moot. There may be nothing left to adjudicate. But if you're claiming damages for a past wrong, even if it's a symbolic amount, and the amount has to be symbolic because usually there's not, nobody broke your bones, you don't have medical bills because someone coughed your microphone, right? So we can't really ask for that kind of stuff. But the constitutional right has a value, even if it's represented by a symbolic dollar, that is enough to keep that lawsuit alive, and that's enough for us to continue litigating to a judgment that declares your rights, and that also gives us the big ticket item, which is the attorney fees, because it costs money to bring these lawsuits, as you might imagine, and sometimes there are also costs as well. We represent people free of charge. We only work on a pro bono basis. We're funded by donors and sometimes by attorney fee awards. We're a nonprofit organization, but also for-profit lawyers, and I spent many years being a for-profit public interest lawyer, are also, of course, entitled to the reasonable market rate. Congress enacted fee shifting in the civil rights area so that these lawsuits would be viable. That's oftentimes the only thing that you can get and the only incentive that a lawyer would have to undergo this task of suing the government. I know that Jeff Childers talked about this earlier this morning. He's right. But the attorney fees, again, as I mentioned earlier, have an important impact on the thinking of some of these boards, and if not on their thinking, then on the thinking of their insurance carriers. So that's why we ask for that. Now, having said all this, there are some cases that are more difficult than others. We think that there's room to push the envelope. We like to make law, and so we're not going to shy away from a case just because there's something legally challenging about it, but we're also not going to use our limited resources to bash our head against the wall. So we may not take lawsuits if they're too adventurous, or sometimes too adventurous for the location in which you're sitting. As you all know, judges differ from place to place, and our federal court system is divided into these regional circuits. Here in Florida, you're in the 11th Circuit. If you're in California, you're in the 9th. I know you heard these numbers, and basically it means that courts there make the law for that grouping of states. When the circuits disagree with each other, that's when the Supreme Court can step in and resolve the conflict among the circuits. Now, I know that the Chief Justice likes to say that there's no such thing as Republican judges or Democratic judges or all federal judges. That's nice. It's not true. I wish it were true, but judges are the product of a political process. You don't get to be a federal judge just because somebody found you in the phone book. Typically, you need to know a senator, and the president needs to select you. And so, not surprisingly, judges will view the law oftentimes through some ideological lens. And it's not a perfect predictor who picked them, and it shouldn't be, but oftentimes it is. And there are some circuits where, after a while, you figure out there's a certain bent to them. So there's some parts of the country where I would be very careful to bring an adventuresome lawsuit, and there are other parts of the country where I'd love to have every lawsuit possible, because I know that the courts there are going to be, much better. Also, sometimes resources are just limited. If there's a good case, but it's too garden variety and like other people can do it, then it may not be a great use of our donor money. It doesn't mean it's a bad lawsuit, but it just may not be something that we would like or some other firm may pass on. And of course, again, there are also lawsuits that don't even involve the First Amendment that at least our organization wouldn't do, but you should not be dissuaded from doing them. They may involve some other theory, and of course, we can also be wrong. It may be the case that we pass on something that somebody else would enjoy. In any event, I think I've given you kind of an overview of what we do and where we are, and I'd love to take it with you into Q&A. So I see some questions. We'll start here up front.
So this is on our school board website, our policy on speaking in public at their meetings. It says speakers before the entire board are not allowed to use props, displays, or any other objects during the presentations. So you can see where this has caused a problem, where we want to demonstrate to parents at the board meetings what things are being portrayed in our children's books. So we've had that problem. And then also, in accordance with the board policy 01.421, the board expects that persons who have signed up to address the board or limit their remarks to subject listed at the time that they signed up, that's fine. That their presentation will not include any defamatory or abusive remarks about that subject.
That's okay. So that's just not constitutional. Send me an email. And by the way, the other thing too, I should say, look, I do respond to emails. Sometimes it can take a while. We are small. We are responsive. Sometimes things take longer to get going than we would like. That's something we're trying to address. We have the same problem every other employer in America has, which is a labor shortage, especially for the specialized work that we do. But that sounds to me good. And as far as the prop thing, this is something we've been looking at. I have not seen any case law on that, but I think that that's vulnerable because, look, if you watch, for example, C-SPAN, if you're tired of board hearings, you want something more exciting, you go to C-SPAN. It is perfectly normal for people to use a presentation, to use a PowerPoint or a chart or something. And if the purpose of the forum is to communicate political ideas back and forth with people, to discuss data that a chart might represent or something, then it is not consistent with the purposes of the forum, I think, to limit you to just words. I think they can regulate the type of exhibit. That's something that we would think about bringing, and that would be a novel lawsuit as far as I could tell. The other part you mentioned, that is just that's slow and over the plate, and we would okay. Yeah, I mean, look. Can you hold a book? Well, that's a problem. Up here, and then we'll go back.
I just want to hone in on the school walkouts. I'm in Florida, Tallahassee. My daughter's middle school. They had a protest against the Criminal Rights and Education Bill, and it was during school hours. I went to the principal about it. He said it is their First Amendment right to do this. Is that right? I mean, it was during school hours. It's disruptive, and kids are participating in this protest on campus. What was it on? Teachers.
Okay. So we would again, there has not been a whole lot of litigation on walkouts yet. This is obviously an issue that's I think very hot right now. It's coming to the forefront. It's something that we're looking at. We're definitely about a year and a half ago, we filed an amicus brief, a friend of the court brief, in a walkout lawsuit in California, and we took the position that this is inherently coercive when the school is organizing a walkout for all the reasons I mentioned here, and we're looking for opportunities to get into that. The schools always say, well, it's up to the students, and we had nothing to do with it. These are just precocious kids who feel very energized about something, and it's up to us to decide whether we want to punish them or not. We have discretion as to whether or not we're going to, hold them under the attendance policy. No, I think this is an area that needs to be explored. I can't tell you that the courts have dealt with it, and also we know that these walkouts are not really organically generated by the students. These are oftentimes, there'll be an advisor to like the GSA club or something. We've seen in some school districts where the schools are giving school resources for the walkout, like in the Portland case where we filed a brief, it was, a lot of school resources were used in terms of, here's some markers, here's some poster board. We're now going to spend school time making posters. That was, and at that point, you can say, look, this is coercive because the teachers are not requiring anyone to go to a demonstration, but the relationship between the teacher and the student is such that it's inherently coercive. You don't want to be the one student doesn't do it. The defense that they'll say, well, we can teach whatever we want. Well, what are you teaching them? How to protest? No, you're teaching them this is the ideology you want them to conform to. So that's an issue. I back there, the American flag shirt. You had your hand up for all. Yeah.
So I filed a formal complaint that one of the school board members violated their code of ethics because she disparaged, not Montessori Liberty by name, but me and other parents. So I filed this complaint, and I followed the person that I have to file it with is the chair, who has no problem at all with this school board member. So, nothing is ever going to happen. And I filed again. They don't say at this point that you have to speak to it, speak to an item on the agenda. They let us talk about what we want. At this point, they did cut me off when I was reading from a book. This was a while ago, so I did never do anything about that. They repeatedly cut off different parents that tried to read from the same book. As soon as you began reading, they shut it off and they told you had to leave. But anyway, I filed the complaint against Jennifer, and I would like now to address the chair during one of the board meetings during the public comment section, but I can't imagine them shutting my microphone off again because they say when they state the rules that you're not allowed to say one of their names, and that you can't speak.
Which district is this?
This is Charlotte Mecklenburg.
Okay.
In North Carolina.
Okay.
And that you're not allowed to speak about specific incidents and name people. And it's considered a personal attack, when really it's just being critical and holding them accountable.
Okay, so personal attacks are protected by the First Amendment, okay? You can absolutely make a personal attack on someone. Defamation is not protected, but defamation has a very specific, narrow meaning in our law, and the school board is not really set up to adjudicate that. If someone thinks they've been defamed, they need to go file a lawsuit. And, most people who think they have defamation claims don't. So, yeah, I know, but I'm talking about, that's right. That's right. Yeah. Sure, what I mean is that she can't accuse you of defamation. Now, you are entitled, you have a First Amendment right to petition the government, and that includes complaining about school board members. One thing about the right to petition in the First Amendment is the courts have held, you have the right to complain to the government, you don't have the right to get a response, okay? So, like, you can write Congress, they don't have to write you back. I can write, Brandon about something, I'm not gonna, he doesn't have to write me back. He doesn't owe me an answer. And they don't even have to read their mail. I mean, as long as there's a bag of mail here, it's great. That's so. I don't know that.
You can't hold them to their code of ethics. There's no legal reason.
If there may be, I don't know if there's any kind of state law in North Carolina that deals with ethics or private cause of action if somebody violates an ethics rule on the board. That is, but as far as the First Amendment is concerned, no, you can't usually sue people just because they're unethical. You can sue them if
You should be able to stand up there and talk about it.
you absolutely have the right to talk about it.
Happy that I didn't get a response from the chair.
You can complain.
I'm not going to do anything.
Yes, you are. The First Amendment protects your right to complain about that and to say so publicly. Yes, it does. So yeah, over here and Kelly, yes. Yeah.
So I'm really starting to talk with teachers, and in our district, the teachers just feel absolutely muted, that they cannot speak out at all. And then the board has these grievance policies, so you cannot address any kind of a grievance in the public policy. But in this, in the public board meeting, but after listening to you, they can make their rule. But to me, it sounds like if that teacher wanted to get up and say something about SEL or whatever, they have every right to do that. But we've had them say, I'm sorry, we've had board member say, I'm sorry, you don't want to discuss that here, you know, and then shut them down. But it sounds to me like that would be.
Well, you're talking about a teacher? So the teacher may be governed by a collective bargaining agreement, and they have an employment contract, and then maybe they've chosen to you know, for example, members of the military can't really criticize the president, you know. Now I don't know. I can't answer the question for this teacher right now as I stand here, whether or not they have a First Amendment claim or not. To what extent can the government, using an employment contract or a collective bargaining agreement, limit an employee's right to talk about the government? I would imagine that there's some interesting law on that, and I would be very careful before I just announced some flippant opinion. I'd have to see what that particular policy is and what court we're in. But they are in a different relationship with the school, so that may be something there. My guess is that, you do have, there's an entire body of law about, this often happens in like sheriff's deputies, okay? So let's suppose that, you know, the sheriff's deputy doesn't endorse the sheriff in his reelection and suddenly he's demoted or something. You know, these cases do come up. And there's a body of law dealing with the speech rights of public employees when they talk about their employer. And it's a little bit more complicated than, say, a citizen who can just go up there. They do have First Amendment rights, but it's analyzed a little bit differently. I'm going to go to this side of the room, and I'll get to everybody, I promise. So how about back there?
I'm from Louisiana, and I have been working, dealing with the district of Ascension Parish, Shaking County, Louisiana, for about a year and a half. I actually recently moved to East Ethridge to see some backstory. But when I was going through the process in Ascension over the mask mandates, one of the things that we stumbled across was a policy that the board voted in, which basically relinquished their vote, and they gave this authority to the superintendent. Further looking into that, we had 59 districts that did this same policy. Now, if you look at the Administrative Procedures Act, we have hurricanes. You guys are familiar with that term. If there's an emergency of some sort where the board cannot convene as normal, then that authority can be given to the superintendent where he can make those decisions without the board's vote. However, the Emergency Procedures Act says that once the board is able to convene as normal, they have that power goes back to the board. So during the COVID mitigations that come through, all of this authority was given to the superintendent, all of the decisions, and therefore the citizens were bypassed as far as, there was no agenda, right? Because it didn't have to go through the board anymore for a vote. So we were completely kind of shut out. With that, would there be any legal footing to come back up or sue for that?
So the citizens didn't have an ability to talk before the board because the board wasn't there.
The superintendent was making those decisions that should have been coming through.
Okay. That's a question of Louisiana law about, you know, how the school board should function, and, you know, I would defer to a Louisiana practitioner on that. It's way beyond what I do. I mean, that's, you know, look, the First Amendment doesn't require that there even be a school, let alone a school board, or that they even hold a public comment meeting, but state law always does, right? We have public schools in every state. There's a Sunshine Act in every state. They can't have secret meetings. Every state requires the school boards to have a public comment period, which means that you've got, you know, a limited public forum in every state to get up there and talk, and that's where the First Amendment kicks in. But if they're not going to show up, that's, yeah. But if there's an irregularity in the meeting, you know, the meeting isn't happening and it's not happening the way it's supposed to be, or they're delegating their vote to some other person, that's a Louisiana issue, and I would urge you to look, because it doesn't sound right to me, but you know, it's Louisiana. I love New Orleans. I've enjoyed being there as a tourist. But okay, let's go that end over there. I'm sorry. Yes.
One county north of here, National County. We at our board meetings have, it's called the respect and civility policy.
Sounds wrong.
So too, but, so
Demanding.
Subjective. So this is their policy to us, the parents and the community members. My daughter got kicked out of her zone school in January because I speak at school board meetings and my social media posts. I've never been trespassed, never been banned, cut off because I wasn't on topic. But that's, I mean, this is, there's a lot. But I'm just talking from another parent. This is like people are very. But to have a policy to say respect and civility policy, I mean, it is our First Amendment right to hold them accountable. So if we come in and say, hey, this is wrong, you guys shouldn't be doing this, we have an issue with this, we don't approve, or this teacher had penis enlargements in an ad, and they're going, well, you can't talk about that they.
Yeah, no, so civility is not a rule they can enforce. And in fact, the Pennsbury School District that you saw here, you heard the solicitor there talk about policy 903. Well, they also had a 922, whatever, which was the civility policy that they enacted after that incident to make things even worse. And they were forced to rescind that because we sued over it. So, you know, civility, the First Amendment does not require you to be civil to the government. Now, loudness, sure, they can prevent you from like screaming and shouting, and you know they can put the decibel meter on you and stuff. And yeah, the Voldemort rule. Yeah, that's something that has to be litigated. But yeah, we're working on it. Okay, let me go back to this side of the mess over here.
So I'm curious, I don't remember the terminology you used, I think you said something like chill, but I'm curious if this is a scenario that would apply there, where you've essentially been intimidated to where you no longer feel comfortable speaking at your Board of Education, right? Is that what you
Yeah.
were saying, Michelle? Okay, so, the second board meeting, pretty large, had, one of our congressmen there to support us and help speak. I was, called out by name a few times by the superintendent and the chairwoman, escorted out by the police for no reason, other than just disagreeing with their mask policy. Second time, myself and my group were prevented from entering the building, to even speak at all. The third time, we were there, I was denied the right to speak, and, one of the other moms, Mike, was coming. And then.
These all sound like things that, you know.
That, it seemed like it would apply. And then they came after my son. And, so there's a lawsuit, a separate lawsuit, personal lawsuit in regards to that. So I'm just curious if that is something that sounds.
In theory, sure. Now, obviously, like with the mask, if they didn't let you in the building because you didn't have a mask on, that's not really a First Amendment issue, I don't think. I mean, I disagree with that. I think the mask thing is stupid, and that's my personal view. But, you know, it's a health hazard if you're breathing, you know. I don't know. But no, definitely, if the microphone is cut off just because you offend these people for some reason, then that's probably an issue. Over here, the blue. No, okay.
So I'm a current candidate for the Osceola County School Board. And at one point, I introduced myself as the current candidate for the school board. And then later on, I had given one of my cards to a parent who has been having an issue. Is that considered a violation of anything? If I even just at my own public comment state that because I was warned not to do so.
I'd have to see what their policy is, but it sounds wrong to me. And by the way, can I identify as a voter in your district? I mean, is that if I can? Yeah,
I'm another candidate, same county, Osceola, another district, though.
I'm going to really identify then as a
chairwoman. I was just wondering, is there any validity to like the pornographic nature in these books? Because it doesn't seem, I'm also part of a book review committee that's reviewing the 4 main books that were pulled and read aloud during a meeting. The very last one, which is All Boys Aren't Blue, is pretty graphic. I mean, we're talking about anal sex, and while there's no pictures, you don't need a picture. I mean, just reading it is sufficient. So is there gonna be any like, are we gonna be able to go after the school districts or change that at all? Are we gonna suffer with these terrible books?
Well, the best solution is for you to win your election, and then, you know, that changes. Now, look, the school library shelves have space for only so many books, and which books get to be there and which don't sounds to me like the courts are going to say that's primarily a political decision of the school district. I would imagine that the school board in San Francisco or, you know, Manhattan feels differently about what books belong there than the school board maybe in your county or somewhere else, and that's America. But you're allowed to complain about it, and you should be allowed to read from those books if you want.
The Florida statute that does address harmful material to children.
And then that's something you can proceed in state court in Florida and try to do. There are states now, I know Georgia just changed their law on this next door. So yes, if there's a mechanism for you to address this under state law to get rid of a book, then go ahead and take advantage of that. We at IFS don't handle that kind of work. We're not, people who sue under various state book statutes. We're there to protect your constitutional right. And I believe you absolutely have a constitutional right to get up before the school board and to complain about the books that are there and to express yourself any way you want, with any viewpoint you want, and try to get things changed that way. If at the end of the day all your neighbors love this book and think that everyone should read it, maybe move, I don't know. But, you know, anyway. I guess I could take people, yeah, I know that we're probably out of time, but no one's kicked me out of here yet, so I'm not going to be, let's go back there and I'll swear.
I'm not sure if you're familiar with Neola at all. Do you know anything about Neola?
Neola, it's not coming to me.
An acronym for Florida uses it for school board policies. It's a company that school board, the districts can go and get policy. Policy is already written. It's a policy.
Yes, okay,
My question is,
I've seen this.
we had this thing with the superintendent, she was trying to take the rights away from the PTA. So the PTA would raise money, she was trying to say that, no, the principal doesn't have the rights to discuss with you guys how you use your funds, it all is up to me, I decide. So what I found out is Neola, I believe, has several, policy, whatever, they might have 3 different versions. But I can't find this. Do you have any information?
I don't know anything, I'm sorry, it's so specific. I really don't know how this operates. No, but I will say this, I mean, it was an issue in Pennsylvania where, some of these policies come out of a book. The School Board Association sells the policies to the boards. And that's great because when it gets struck down in one district, all the other ones need to pay attention. So I'll take one more question, then I guess we probably should so. You've been waiting a long time, so I'm sorry.
Okay, and I live in Miami-Dade, and we have a school board member who was convicted of a felony, I believe in New Jersey.
Wonderful.
And where he was working as as an administrator of schools up in New Jersey, and he embezzled funds from it. And he was kicked out of New Jersey, and under the statement that he lost his license and would no longer be able to work in New Jersey. So what he did was he came down to Miami and started all over. And now he's vice chair on our school board, and he's planning on promoting him to superintendent.
Wonderful.
Yes. And right now, what they have during public comment in our school board meetings, we all, like in Moms for Liberty, we know about this, we've dug up this information, but they state in public comment that we are not allowed to say anything negative about individual school board members. It's obvious to protect him. It was also to prevent the previous superintendent who had paid money to cover up sex abuse offenses in Miami-Dade. And so is this actually allowable? That's what I want to know.
Can they prevent you from criticizing a school board member? No.
If you say a member, they will shut your mic off and you are done.
Again, that's something that we would want to challenge, and it's an issue in the Brevard case. It was an issue in Pennsbury. It's an issue in a number of school districts. And no, you are allowed to discuss government officials. We think you should be able to do that, and we expect that there will be a decision on that here in Florida sometime soon. And yeah, but it's also how they interpret the policy too. Well, thank you guys so much. You've been super patient, and go out there and win. Thanks.